Hi, my name is Nadav Ravid. I'm the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country in negotiating their commercial real estate leases. This year, as many of you know, we've been covering a lot of the cases that have been analyzing the issue of whether or not the rent is due in light of COVID-19. And early on were looking at cases that held strongly in favor of the landlords and basically held that the force majeure provision, which typically would say that despite any type of force majeure event, the rent was still due, typically would be dispositive and the landlords would win based on that. And then even when the tenants raised common law doctrines of impossibility and frustration of purpose, the courts rejected those defenses as being inapplicable for a variety of reasons. And so that was the conventional wisdom that the rent would still be due, and that's basically what most people believed. And then we started seeing several cases trickle in that held the opposite position, which was that for a variety of reasons, sometimes because of specific language in those leases, sometimes the leases contain the exact same language where earlier cases held in favor of the landlords. And these later cases started to support the tenant side and said that at least during the time when there was a government ordered shutdown, when the tenants were prohibited from operating, during that period of time, the rent would not be due. And in some cases, maybe there was a meeting of the middle, or at least a proportionate amount of the rent was excused. And so this month, we're going to talk about another case which held again in favor of the tenant. And this case came down last month where a tenant, a retailer named Brooklyn Babies and Toddlers, stopped paying rent because of the government shutdown out of New York. And the courts analyzed the issues. And what's interesting about this case is that unlike all of the previous ones that we analyzed, there was no force majeure provision in this lease. And so it was interesting to see what would happen. Again, typically you would have a lease which would say if there's a force majeure event, and a lot of people would consider COVID-19 to be a force majeure event, whether or not it is another subject. But assuming that it would be considered a force majeure event, a lot of the landlords took the position that said that, well, yes, it's a force majeure event, but my force majeure provision in the lease specifically says that even though there's a force majeure event, you still have to pay me the rent, and therefore the rent is still due. And in this case, the landlords didn't have the benefit of that type of an argument because the lease was silent on the issue. And so this is pretty interesting to see how would a court analyze a lease that didn't have a provision. By the way, we mentioned before that in California, a very prominent, often used lease form is the AIR lease form. And that lease form does not have a force majeure event. So it would be interesting to see if California courts would interpret the same reasoning or apply the same reasoning to California cases analyzing those leases. But in any event, the court in New York, in this case, held that the force majeure, well, the tenant argued that they were excused from paying rent for three reasons. One was the force majeure. It said, well, there was a force majeure event and therefore I'm excused from paying rent. And the court rejected that because the lease itself did not have the force majeure provision. But the tenant then also claimed that they were excused from paying rent because of the doctrine of impossibility and frustration of purpose. And the court agreed with the tenant that the doctrine of impossibility did apply. Basically, what the court said was the COVID-19 event was unforeseeable, which is a requirement for doctrine of impossibility to apply, and performance became objectively impossible. It's not enough that it becomes more expensive, it just had to be impossible. And because of the government ordered shutdown, it was considered impossible. You can't operate when the law says you're not permitted to operate. And so the court didn't even get to frustration of purpose. It basically just held that tenant was excused from paying rent during this government order shutdown, and the tenant was excused from paying the rent, and that was the end of it. And so this is another case that is interesting to add to the list of cases that tenants can use to justify their position. Remember last month we covered another case that actually held that the doctrine of impossibility did not apply, but the doctrine of frustration of purpose did apply out of Massachusetts, out of Boston. So here we have now back-to-back cases that are ruling in favor of the tenant. Again, there are other cases that came down last month that again held in favor of the landlord, analyzing the same types of issues. And so we're stuck at this place where there is no consistent outcome throughout the court systems on answering the question of whether or not the rent is due. Conventional wisdom in the leasing community still remains holding or under the expectation that the landlords have the better argument and that the landlords would most likely be the prevailing party in these lawsuits. That's the conventional wisdom. Yet you do have these cases that are coming down that are starting to chip away at that conventional wisdom and showing that the tenants at least have some arguments and in some cases will prevail by making their arguments. So it's still to be determined to see what will end up being the consistent position of the question of whether or not rent is due. And we will keep monitoring all the cases and keep you updated. And that's it. Thank you very much.